Brought to you by Wall Street Prison Consultants.
I'm Olivia, a custody advisor at Wall Street Prison Consultants. Today I'm going to explain pretrial motions. Much of the action in a case occurs before the trial even begins in the form of pretrial motions. These procedural devices can shape the trajectory of the trial, determining what evidence is admissible, which witnesses can testify, and sometimes, whether the trial will proceed at all. Pretrial motions are formal requests made by either the defense or the prosecution to the court, seeking a particular order or ruling. These motions are presented before the actual trial starts. The objective is often to set the ground rules for the trial, ensuring that it is conducted fairly and justly. The types of pretrial motions include: Number 1. Motion to dismiss. Perhaps the most significant motion for the defense, a motion to dismiss seeks to have the case thrown out before it even begins. Reasons for this motion can range from insufficient evidence, procedural mistakes, to violations of a defendant's rights. Number 2. Motion for summary judgment. Common in civil cases, this motion asserts that there are no factual disputes and the case can be decided on its legal merits without going to trial. Number 3. Motion to suppress. This motion seeks to exclude evidence that was obtained illegally or in violation of a defendant's rights. For example, evidence found during an unlawful search could be rendered inadmissible if this motion is granted. Number 4. Motion in limine. Aiming to prevent certain pieces of evidence or testimony from being presented to the jury, this motion is usually grounded on concerns about prejudice, irrelevance, or other factors that could taint the trial's fairness. Number 5. Motion for change of venue. If there's a belief that a fair trial isn't possible in the current location, perhaps due to media coverage or strong public opinion, a motion can be made to move the trial to a different jurisdiction. Number 6. Motion for severance. In cases with multiple defendants, one may argue that they should be tried separately to ensure fairness, leading to this motion. Pretrial motions important because they can shape the trial and determine what evidence and testimonies are admissible. Pretrial motions can significantly influence the trial's narrative. They ensure that juries make decisions based on relevant, legal, and unbiased information. Protect rights in motions to suppress and play a pivotal role in upholding the constitutional rights of defendants. They prevent violations like unlawful searches or coerced confessions from impacting the trial's outcome. Streamlining the process. By addressing issues before the trial, motions can make the actual trial shorter and more focused. In some instances, they can even negate the need for a trial, saving time and resources for all parties involved. Strategy and leverage. From a tactical perspective, the outcomes of certain motions can influence the strategies of both the defense and the prosecution. For instance, if key evidence is ruled inadmissible, it might push one party towards considering a plea deal. For more information on pretrial motions, you should contact a prison consultant. Now, let's talk about Wall Street Prison Consultants. Hiring Wall Street Prison Consultants, when facing federal criminal charges, can provide valuable support and guidance through a complex and intimidating process, and help defendants take advantage of programs offering substantial early release. Here's why someone in this situation might consider hiring them. While there's no shortage of criminal defense attorneys to represent defendants in the courtroom, most attorneys' knowledge of custody ends at the prison gates, leaving clients to fend for themselves after the judge renders sentencing. According to legal statistics, 97% of those charged are convicted, with thousands of white-collar defendants sentenced to federal prison each year, the majority being first-time offenders clueless what to expect upon entering custody. Wall Street's services begin long before a defendant even goes inside, and continues after release. Depending on when retained, they guide clients through indictment, trial, pleas, sentencing, and prison survival all the way through supervised release. By using their services, clients develop an edge when dealing with their lawyers. Wall Street takes the mystery out of the judicial court process by educating clients with easy-to-understand step-by-step explanations on federal criminal statutes, indictments, and how it applies to them, so they can make educated decisions about their case and understand the ramifications of a criminal trial versus taking a plea agreement. As I'm sure you're aware, prisons can be dangerous places, and having knowledge about prison policies, early release programs, medical care, inmate jobs, dealing with gangs, staff interactions, and the basic politics surrounding incarceration are the keys to surviving successfully and returning home safely. Many defendants are often confused listening to lawyers, friends, and family members about what will happen to them and whether hiring a prison survival consultant is helpful at all. While others may have opinions, they are typically not qualified opinions. And once sentenced, it's the defendant's freedom and safety at stake, with everyone else's well-meaning opinions being worthless. When going to prison, knowledge is key, and hiring a prison consultant with facts instead of uninformed viewpoints can be the difference between early release and spending unnecessary time in custody. Wall Street prison consultants have detailed knowledge of both the federal legal system and the inner workings of the federal prison system. Their expertise can demystify the process for defendants and their families and help them prepare for what lies ahead by offering strategies and advice on how to reduce sentencing length through various legal channels and inmate programs, focusing on aspects legal teams might overlook. If a prison sentence is unavoidable, Wall Street prepares defendants for the realities of prison life, teaches them survival tactics, and helps with the emotional transition from freedom to confinement, as well as securing designation to a preferred facility that meets an inmate's needs and aligns with their specific security level or health requirements. Wall Street offers support in planning for life after release, including supervised release requirements and re-entry into society, and doesn't make false promises, but provide a realistic view of the situation and what can be done to mitigate it. While they are not lawyers, they often work in conjunction with legal teams to make sure that all aspects of the defendant's situation are being considered and offer more personalized and continuous support compared to a legal team, especially during the post-trial and imprisonment stages. In essence, they can provide comprehensive support tailored to the unique needs and challenges faced by someone charged with a federal crime, and help them navigate through both the legal and prison systems. It's a specialized service that can add an extra layer of support and guidance that complements the legal defense, but doesn't replace the need for competent legal representation. For more information, contact the director and founder of Wall Street Prison Consultants, Larry Levine, at 213-948-1069, or by email at help@wallstreetprisonconsultants.com. Or visit us on the web at wallstreetprisonconsultants.com.